Ladies and gentlemen, may I have your attention? The forum is about to begin. My name is Zahida Zahuri and I will be the moderator for today's forum discussion. Before we start, I would like to say thank you to all for coming. Tonight is your opportunity to listen to the intelligent members of the panel in regards to today's topic, which is what is the true nature of jurisprudence and whether mere reliance on statutory provisions and case law is sufficient in understanding the meaning and scope of law. There are so many misconceptions regarding the subject of jurisprudence. One common misconception is that jurisprudence is irrelevant to the practice of law and is merely concerned with philosophical inquiries suited to academics. So, we are honored to invite our panel to share their opinion and thoughts and help us all to achieve clarity on this topic. Before the discussion begins, allow me to introduce the members of the panel. First and foremost, we have Ms. Najwa, the best law student of UiTM Shah Alam. Secondly, we have Ms. Siti Zulaika, the president of UiTM's Jurisprudence Club. And last but not least, Mr. Aiman, a legal practitioner from Megah Associates. Thank you all for being here. Before the sharing session begins, I shall first briefly explain what is jurisprudence. The term jurisprudence is derived from Latin terms juris and prudentia, which conjunctively mean the study, knowledge of science of law. From a general perspective, jurisprudence is largely concerned with questions that all students of law must grapple with, which are, what is law and what is justice? In simple words, jurisprudence refers to the study of the evolutions of the area of law. Without further ado, I would like to invite the first speaker, Mr. Najwa, to deliver her speech. The floor is yours.
Thank you, Ms. Haida. First of all, thank you so much for having me here today to discuss on this engrossing topic. In my standpoint, jurisprudence is not only confined to statutory provisions and law cases, as it is also a product of the jurists and philosophers' thoughts. This is for the fact that different schools of thought exist to act as a complementary element in understanding the true nature of jurisprudence itself. Let us take a deeper look at John Austin's school of thought, namely legal positivism. In John Austin's analysis, laws are properly so called as distinguished from rules of positive morality, dogmatic or natural law. Laws are commands issued by the sovereign of the country to the subjects, and that something is a command only there is a sanction behind it. Austin also held that the law in a precedent is to be found in its ratio decidendi, and that customary rules do not become legal rules until they are recognized by the courts. On the other side of the coin, John Stuart Mill, or more known as J.S. Mill, who was one of the naturalists, has an opposite viewpoint over the law. According to J.S. Mill, laws were discovered through observation and induction, and it requires empirical verification. Mill believes that humans are to be understood as belonging to the natural order. As we can see here, positivists aim to work out theories that apply to people or societies broadly, while the naturalists focus more on themes that are true at some time or in some places, while working to learn which elements of a complex environment affected what was seen or heard. Even these two philosophers' thoughts could already show the colorfulness in the law itself, as well as the true nature of jurisprudence. This is a clear manifestation that law is not only about complying to one single rigid rule, but it is also about embracing different beliefs of the jurists and philosophers. It is really upsetting for the fact that majority of postgraduate students, especially PhD students, only have the idea of legal provisions and case law when the word jurisprudence comes to their mind. Mere reliance on statutes and case law is inadequate or insufficient in understanding the meaning and scope of the law itself. Awareness of the evolution of jurists and philosophers' thoughts provides a key to an understanding of change as a basic phenomenon of the law. For instance, there's a change which emerged in the decision of the House of Lords in the case of Peach and Smith, 1995, whereby there's a modification of views concerning nervous shock in tortious law, an area in which there's a lot of jurisprudential speculation and debate. In this case, the court was of the view that in the case of direct victims, if the defendant could reasonably foresee that his conduct would expose the plaintiff to the risk of personal injury, it would be relevant that the extent of the damage was unforeseeable because the plaintiff has special sensitivities. Nevertheless, the majority judgment has been critically received by most academics. The minority had followed the ruling of the Court of Appeal, finding that in all cases of psychiatric injury, the test in establishing a duty of care was whether the psychiatric damage were foreseeable, and not just whether or not it was foreseeable that harm of any type might come to the plaintiff. On a final note, the numerous number of jurists and philosophers' thoughts not only brings out more understanding in the meaning and scope of the law itself, but it also tells us the logic, rationale, and reasonableness of having the law itself. Therefore, I truly believe that the nature of jurisprudence does not only refer to the statutory provisions or case law, as reliance on various thinking of jurists and philosophers is very much important in knowing the true nature of jurisprudence. That's all from my side. Thank you.
Thank you, Ms. Najwa, for the speech. Ladies and gentlemen, Ms. Najwa has emphasized that practicing or reading law is not only about complying with one single rigid rule, but it's also about embracing different beliefs of the jurists and philosophers. She also highlighted that jurisprudence is important in helping many law practitioners to understand the logic and rationale behind the law. Now, it will be interesting to hear from the President of Jurisprudence Club of UiTM, Ms. Zulaika herself. The floor is yours.
Thank you so much, Ms. Zahida. Before I begin with my own standpoint, I think what has been delivered by Ms. Najwa just now was very wonderful and insightful to all of us here. So, as the representative from Jurisprudence Club, it is my huge honor to be joining the forum today with the remarkable panelists beside me. So, when we are talking about the nature of jurisprudence, I believe that each of us here specifically have our own view. However, in highlighting the topic, I believe that the study of jurisprudence may be seen from broad approach of facts and thoughts. This is because the relevance of jurisprudence to life in general and everyday law in particular contributed to the importance of knowing the changing or evolution of the environment itself. To simplify, what may have been normal to the people back in the 1980s could be as strange in 2021 today. This is due to the evolution of the environment through the continuous shifting views and transformation of social institutions, which tend to be reflected in jurisprudence in line with the way of life of the society. For deeper explanation, jurisprudence reflected heavily on our society. The majority of modern jurists demonstrate a profound concern for social justice and communal harmony. For instance, Ronald Dworkin's key beliefs is that the law should be grounded in moral integrity, understood as the moral idea that the state should act on principle, so each member of the community is treated as an equal. To give example on this, the perception of law as an aspect of a changing social environment and attitudes identify contemporary juristic thinking involving the right of life. In the case of Re-A children in the year of 2000, the court ruled on the lawfulness of the surgical separation of conjoined twins, where the quality of life of each twin was highlighted. What happened in this case is that the Court of Appeal denied the parents' appeal of the lower court decision that the surgical separation of conjoined twins would be lawful. The parents here refused to consent to surgery to separate the twins. The twins, which is Mary and Jody, if separated, Jody could live an independent life. However, Mary would die because her life depended on Jody's circulatory system, hence without separation, Jody's heart failed within months and both of the twins would die. The court discussed under the family law where in a best interest analysis, the court balanced the right of life for each twin and granted permission to operate as the least detrimental choice. Whereas under criminal law, taking into account the principle of sanctity of life, the second balancing test of the twins' right led to the court to conclude that the lesser evil conduct would be to operate the twins, which is here to save Jody. In concluding my stance, the decision of the court in this case are inclined to appear to morally giving what the public at large would want, in which it is still considered a murder in part of Mary, but the judgment seemed to do what was morally permissible to do here after applying the principle under family law and also criminal law. This is due to the fact that there is a lack of precedent, as there was no settled principle in law at the time that the Court of Appeal could act on, hence allowing for morality to creep in. Therefore, disbanding of the law to achieve an utilitarian goal where the two lives were at stake has ultimately opened the door to other potential lawful acquittal cases. That would be all for my brief sharing for today, and I hope my sharing could contribute to open eyes of the audience joining today for the fact that the study of jurisprudence is definitely not limited to primary sources of law and could be seen crystal clear from our surroundings and circumstances. Thank you.
Thank you, Ms. Zulaika. Now, it is really interesting that Ms. Zulaika quoted the controversial case of Re-A children to prove that jurisprudence could be derived through the evolution or changes of the social environment. This can be seen where the court has decided the case based on morality rather than what the law ought to be. Now, how about you, Mr. Aiman? What is your idea and perception about the subject of jurisprudence?
Thank you to Ms. Zahida for such a wonderful question. Before I start my speech, I would like to quote a famous English philosopher who was born in 1588. Quote unquote, law is a formal glue that holds fundamentally disorganized societies together. So I think it is very important to every law believer out there to understand that there will be no law if there is no strong jurisprudence descendant in it. Jurisprudence has various branches and is very essential to be studied. For example, the natural school of law. Through natural law, we understand that nature creates law and it has its own way of providing justice. Then at that time, there is natural justice which will of course provide justice to them. Over the years, the natural law theory has evolved in a bunch of ways and is to be found in a lot of cases. For example, in the case of Corbett seeking Corbett, a transgender woman underwent a sex operation and married the petitioner who knew about the operation. However, the court ordered the marriage to be annulled on the ground that a marriage between a man and a person who had undergone a sex change was null and void since it could not involve the natural biological determined consequences of marriage. The judge based his judgment on the biological aspect of marriage, which was regarded as the foundation of marriage, and it lacks requirement in it, thus making the judge find no difficulty in making those decisions. So, jurisprudence will help us to understand law. It is the grammar of law as jurisprudence give language to law which could be understood by everyone, by these followers. Jurisprudence includes the instruction on how a law should be written and spoken correctly and give a correct interpretation of law. Jurisprudence helps to understand the idea behind any law and answers questions like why a particular law exists, what is the purpose of this existence of this law. For example, the Penal Code. The Penal Code exists because in case of occurrence of any criminal act, the Penal Code states whether that act is a crime or not, and if it is then up to what extent it is punishable and determines the nature of the criminal act. In practice, in nowadays, jurisprudence also will help to present a case. Jurisprudence helps the lawyer to present a case in the court of law, not only to the judges, but it also helps the lawyers to determine the situation and nature of the case and claim for justice with the help of correct law. It trains the mind of a lawyer into legal ways of thought and enables him to bring to bear on his work that legal acumen which is essential for his talk. To conclude, it is very important to not just to postgraduate departments of law, but every law believer or practitioner out there, that the study of jurisprudence can be valuable in that it ensures the perceptions of the law in the setting of a comprehensible, changing world. One day, those perceptions will appear, and that is where jurisprudence will help you. That's all from me. Back to Ms. Zahida.
Thank you, Mr. Aiman, for pointing out the fact that not only jurisprudence help us, law students, in learning and understanding the law, but it also helps lawyers and judges to dictate the nature of the case in the courts. Ladies and gentlemen, from all the points given by the fellow panelists, we can conclude that law students must study jurisprudence in order to have the ability to comprehend law in totality and not to rely on the statutory provision and case law only, as what most PhD students think. This is due to the fact that in the absence of jurisprudence, a lawyer may be able to detect issues relating to non-compliance with rules and regulation, but not necessarily those relating to the interpretation and the application of the law. This ability can only be obtained through the development of critical reasoning skills from the study of jurisprudence. With that being said, ladies and gentlemen, we finally come to the end part of our forum discussion. We would like to say thank you again to the fellow panelists, and we hope that this discussion will be beneficial for everybody. Have a good night, everyone.